Hi, welcome to this webinar on guidelines fundamentals. This is going to be on finding severity levels, calculating criminal history, and then using those two components to find the presumptive sentence for a single offense that has no modifiers attached to it, such as attempts or weapons or anything else that might skew it away from a basic guidelines sentence. Before we start, though, we're going to have a couple of these before we begin slides, where we explain a couple of things before we dive into the full topic. This one is on effective dates. The guidelines are in effect August 1st through July 31st of the following year, except for this year when they went into effect on September 15th because of the delayed legislative session. So this year we have guidelines in effect September 15th through July 31st of 2022. And this is for offenses committed within those ranges, within that range. So we don't really have a concept such as the current guidelines. Normally when we think of current, we're looking at the calendar, we're seeing the today's date, and we're saying this is current. No, this is current based on the date of offense. So we always use the guidelines in effect when the current offense occurred to find everything related to the offense, such as the severity level, the presumptive sentence, and then if they exist, which they won't in this training, modifiers or mandatory minimums. So when we think of current, we're thinking of the guidelines in effect when the current offense occurs. And in 2019, the Commission was very clear when it said these changes that we're making in 2019 are going to be prospective, meaning they're going to look at offenses committed on 2019 forward through July 31st of 2020. And they also left that policy in the 2020 book when it talked about changes that were made to the presumptive stayed maximum for probation. But then Mr. Robinette challenged this notion that we use the guidelines in effect when the current offense occurs for finding everything, not just the severity level or the presumptive sentence, but everything. And in this case, it was criminal history calculation, because in 2019, the guidelines changed significantly for how criminal history was calculated. Mr. Robinette appealed his case to the appellate court, and they agreed with him. And then the Minnesota Supreme Court affirmed that appellate court decision. So what that means for you is that the policies that went into effect in 2019 for calculating criminal history are going to apply regardless of the offense date. But here's what's important. Provided that they were pending sentencing when those took effect, August 1st of 2019. So you might have an offense that was committed on December 28th, 2018, and it's going to be sentenced on October 1st of 2021. The guidelines that you would use pre-Robinette to calculate everything would have been the 2018 guidelines, because those were in effect when the offense was committed. However, in a post-Robinette world that we now live in, we would use the 2019 guidelines to calculate the criminal history score. So this means that you are still using a single guideline book to find all of the items that pertain to the current offense, and then you're using these single policies to calculate the criminal history. So we don't want to think again about that we're bouncing back and forth between books. That's not the case. We still use the book that's in effect when the current offense occurs, but regardless of that offense, we apply the 2019 criminal history calculation. And we call it that simply for ease of use. If you use the electronic worksheet system, that system has been updated to reflect all of the changes from Robinette. But if you're a non-probation practitioner, you just want to use those 2019 guidelines and let that part of 2B1 through 2B7 be your guiding principles for calculating criminal history. And what those 2019 changes did was they first eliminated the criminal history type of within original probation period, which is specifically what Mr. Robinette had appealed on his case, is that because that went away in 2019, it should not apply to him in 2018. Additionally, it allows for the court to waive the custody status, which is calculated at either 1 point or 1/2 point, depending on what the offense of custody is. And it changed the terms of decay for misdemeanors, gross misdemeanors, and felonies. One additional thing that it did was it eliminated custody status for stay of adjudication. So I want to keep that in the back of our minds for when we get to custody status calculation and we start talking about that. So now we just want to modify that first slide a little bit, and we want to keep the box on the left, which tells us which guidelines to use to find the severity level and the presumptive sentence and anything else related to the current offense. But we're going to modify the box on the right that says, provided that they were pending sentencing when the Supreme Court affirmed Mr. Robinette's case, then the 2019 guidelines will apply to criminal history calculation. Now, if you're listening to this webinar because you have a case that you're trying to calculate criminal history for, this is exactly that situation. Regardless of the date of offense, it's obvious that that case has not been sentenced. Therefore, all of these changes would apply. The first thing that we want to look at are the sentencing grids. This standard grid is the grid that has been in effect with the commission since its inception in 1980. This is the numeric grid, if you will, and you'll see what I mean when we move to the other grids. The current grid ranks offenses from 1 to 11. If you have an offense that occurred before 2002, you would see rankings 1 to 10 because the legislature created a felony DWI, so we had to insert that. That was really the biggest change that happened to this grid, was the creation of felony DWI, inserting that at severity level 7 and sliding everything up. So down the side, we find the severity level of the current offense, and you'll see some offenses in italics there. Those are examples of the offenses that are found at that severity level, the most common ones that you find at that severity level. We do have tables in the guidelines section 5A and 5B that will help you find the severity level for the current offense. And that's going to be the next section that we do in this webinar. So for now, let's just say the severity level is found in the along the side, and then across the top is where we find the criminal history score. after we do all of those calculations. And then where those meet, the severity level and the criminal history score, where you find that box, that's the presumptive sentence. You can see that we're pointing to a box that is not shaded. That means it's a prison sentence. If the box is shaded, it means that the prison sentence is imposed, but is then stayed for a specified period of time. In those prison sentence boxes, we also have a range that is calculated to reflect 15% down and 20% up from that presumptive sentence, which is in the box we're pointing to 60 months. So in that situation of a severity level 7 with a criminal history score of 3, the court can impose a sentence anywhere from 51 to 72 months commit, and there would be no departure. Anything outside of that box would be a departure. If it's a stayed sentence, there is no range made available. That's a statutory item, that 15% down, 20% up calculation for offenses that are going to prison. So if the defendant is having their sentence stayed, or if it is stayed sentence and they're demanding execution of that sentence, which is not a presumptive prison sentence, then there is no range assigned to those boxes, and it is just that static number that's reflected there. The drug offender grid came into effect in 2016, and it works exactly the same way, except you'll see that the severity levels are different. Here we have D1 through D9. So we think D for drug, and then 1 through 9. So those are the severity levels. Still across the top is the criminal history calculation. Contained in each box is the presumptive sentence, and we still see the shaded boxes representing stayed sentences and non-shaded representing prison terms, with that range of 15 to 20%. The last grid that we have is the sex offender grid. And if we were doing a training before September 15th of 2021, this grid would have been in between the standard and the drug grid, because this is the second grid that came into effect with the guidelines. But because there was a change to it this year, I moved it to the end. Again, everything works, excuse me, the same way. But here we have an alpha grid, severity level A through I being the lowest. The grid that was in effect from 2006 to 2020 had severity levels A through H. H used to be failure to register, but when the legislature created that new criminal sexual conduct 5th degree offense, the commission needed to put it on this grid, but they didn't want to put it down below failure to register because they didn't feel that it was a lesser offense than failure to register. And that's really the one of the things about the grid that you'll see as you start to work with them is that the higher you go in severity level, the harsher the offense and the longer the sentence. So because they felt that this was because they felt failure to register was not a higher offense than this new 5th degree, they actually dropped down and created a new level I and inserted failure to register there. Or put failure to register there and inserted, there we go, the criminal sexual conduct 5th degree at severity level H. So that might get a little tricky when you're looking at previous criminal history scores and criminal history calculation rather, and you see failure to registers at severity level H. Those just need to be changed to severity level I, but they'll continue to work exactly the same. And changing the severity level, for example, on a failure to register from an H to an I, that's the appropriate thing to do. Just like it would be appropriate to take a controlled substance fifth degree that happened before August of 2016 and change it to a D2 if the current offense is after August of 2016. So updating severity levels on priors is something that's also an important component of criminal history, although I can appreciate the fact that it ultimately doesn't necessarily affect the points or the total score. We do want to present work that is complete and accurate and up to date. So sometimes changing those severity levels is an important element of verifying that it's correct. You'll notice that this grid also contains the shaded and non-shaded boxes, but because failure to register carries a statutory minimum sentence of a commit for a specified period, depending on if it's a first or subsequent, they had to continue that non-shaded box below a shaded box. So while it might seem confounding at first, it is just those boxes within the shaded area that remain the presumptive stayed sentences. Everything in non-shaded is a presumptive commit, and those durations are afforded the range. This is what we were talking about when we said how the statutes define severity levels. And it's really important that we are using the statutes in effect when the current offense occurs to define the severity level. So we said it might have been an H rather, when it was committed, that failure to register, but for criminal history purposes, now it's been updated and it's an I. Well, that's somewhat the same concept when we're using statutes to find the severity level of the current offense. We're using the statutes in effect when that offense occurred to find that severity level. There are three ways that the commission determines what a severity level will be. They look at what the offense is as a whole. They look at the offense and the different components of the offense that might make one way of committing the offense more severe than another way to commit the offense. Or they might look at the penalty statute to decide whether or not this is something that, regardless of how it was committed, it's really the monetary value or the financial loss that's going to dictate how we rank that offense. So one set of offenses that are ranked based on the overarching offense are drug offenses. These are offenses where you can see our boxes right below a controlled substance third degree. And when we cite the statute in the table, this is the table from section 5B, which is the table I recommend you use. This is the table that is outlined by statute number. The table in 5A is knowing the severity level and going to that to verify it. So I really recommend, if you're searching for the severity level, you use table 5B. So in this situation, when there's no subdivision cited on the table, then all of the offenses that are committed under that statute are ranked the same. So here the commission has said, whatever you did to get you a conviction of third degree controlled substance, that's going to be a severity level D6. So the commission didn't look at whether it was sale or possession or what the drug was. They just said if you got convicted of a third degree, it's a D6. But in other situations, the commission will look at the different components of the statute that actually dictate different ways an offense can be committed, and they can determine that some ways an offense is committed are more drastic, if you will, harsher, more severe than other ways an offense will be committed. So we always want to make certain that we have a full and complete statute, and that we use that when we go into the table to find the severity level. So here we're using a criminal sexual conduct second degree, and we can see that that would be a severity level B or a severity level D, depending on what the conviction offense statute was. And it is a significant difference there. An offense ranked at severity level D is a stay for 36 months. A conviction at severity level B is a commit for 90 months. So we want to make certain that we are always using the correct severity level based on the full and complete statute, when that is what is used to find the severity level. And that last way that we talked about was monetary offenses, or offenses that involve some level of financial loss. And those are ranked based on the penalty statute, because in those situations, it is the penalty statute that dictates. You'll have a conviction statute that explains how the offense was committed, and then the penalty statute, which explains the result of the offense and includes the penalty for that crime. And so here I've got a check offense, a check forgery, where we can see three different levels, and there's actually a fourth level that's on the page previous to this one that is the highest severity level of check forgery, which for checks over $35,000. We hope that the complaint contains all of the statutory information that you need, but it might not. So you might see for check forgery, for example, a statute of 609.631 subdivision 2 or subdivision 3. Those are the ways that the person has committed this check forgery offense. You might not see a subdivision 4 in the complaint. It might not populate for Minces if you're using the electronic worksheet system. So what you have to do is try to find this section in the severity level table. And the way that I would recommend that is you start from the left. I'm holding up my right hand. You start from the right and move to the left, removing things. Okay, I don't have a subdivision 4. So I need to find 631. So I need to get into the statute table and find 609.631. And once I find that, hopefully then my complaint or my charging description, my probable cause, will contain information telling me what the amount was, so that I can make the severity level track that. But that's a very important part. We hope that it's included in the complaint so that you can find it, because oftentimes this penalty statute it contains the most important information for theft and theft-related offenses and other monetary offenses that involve financial loss. And the last table that I want to pull out and talk about are theft offense list. I want to talk about the theft offense list. And these are theft and theft-related crimes where the conviction statute can be all over the place, not just in Chapter 609, which is the large criminal code for Minnesota, but conviction statutes that can be found in other chapters. But all of these are dictated by two penalty statutes. And they're ranked at either severity level 2 or severity level 3, depending on that amount, which is outlined in the statute. So this is one where, again, we want to hope that the statute, the penalty statute is included, but if it's not, then we have to look at whether or not it's on this table and what the amount was. When we have a theft under $5,000, we hope to see the penalty statute of 60952 subdivision 33A, which puts us at a severity level 2. When we have an offense off this list and we see that the crime is over 5,000, we hope to see the penalty statute of 609523 parent 2, which tells us it's at a severity level 3. But I want to call your attention to the boxed penalties, the boxed conviction statute there, 60952 subdivision 2 parent A parent 1. That is the term that I use is basic theft of property. That is the theft of property statute that can go with a multitude of different penalty statutes, which then can affect the severity level. But most of the time, this theft statute is going to go with either a severity level 2 or a severity level 3. And if ever we're unclear, because when we're looking in that statute table in 5B and we see this offense ranked at a 4, we want to ask ourselves, wait a minute, what did they do? Because ultimately there are very specific crimes ranked at other than 2 or 3. And if that's not the situation, then you're going to go with the monetary amount of 2 or 3 rather than the specific article that was stolen. And the other thing that we want to be extremely careful of is when we're looking at the penalty statute 60952 subdivision 3 parent 2, we will also see that in a couple of places in the severity level table at different rankings, most commonly a severity level 4. That statute is very interesting. If you were to go and look at it in the Revisor of Statute table, Revisor of Statutes website, that statute includes theft over 5,000, theft of a controlled substance, theft of an incendiary device, all ranked differently than that theft over 5,000 one. So here again, we want to ask the question, what was stolen? And if it wasn't a controlled substance, if it wasn't an incendiary device, then we want to go with the severity level 3. If you use the electronic worksheet system, some of these severity levels will populate on their own because there is a conviction statute. The penalty is contained within that statute. We can insert that in there to auto-populate. Certainly you want to verify that it's correct. We can't do that though with monetary offenses because, again, for that specific reason, the penalty statute is not always listed, and sometimes the conviction statute can point to multiple severity levels. So we always want to first ask the question, what did they do? Especially when you have this theft of property under 2A1. That's where the good question of what did they do will help you determine what the severity level is that you should assign. The next part that we're going to talk about is the level of sentence, which is really important when it comes to understanding how sentences are imposed in Minnesota. which is helpful for determining an out-of-state sentence that needs to be equated, but also for determining where something is going to go in criminal history, because it's not always obvious based on the offense they plead guilty to or are convicted of. So when we talk about level of sentence, one of the terms that we use is imposed sentence. And the imposed sentence points specifically to the duration that is imposed by the court for the sentence. That can either be stayed or executed, where they can have a prison term, a jail term, or a prison or jail term that is then given a stay of execution. So they've stayed that person going to prison or jail for a specified period of time. And it's really that specified period of time. That's the guiding principle right there. And in Minnesota, we actually have 3 statutes that govern what those durations are connected to that level of sentence. These are found in 609.02, subdivision 2, 3, and 4. Subdivision 2 covers felonies, and it says that the sentence duration will be more than 1 year, which is where we have a year and a day, because a day is more than 1 year. When we have an imposed sentence, we have a recording of guilt, a finding of guilt by the court. That's really important. And a couple of slides from now, we're gonna talk about something I call non-conviction dispositions. When we have an imposed sentence, we have a conviction. And we can't have a sentence without a conviction. So that's really an important component to a sentence. Not just entering a guilty plea or being found guilty by a jury, but the court finding guilt and then imposing that sentence duration for a felony of at least a year and a day, which is then either stayed or imposed, i.e. they go to prison. And those offenses are going to be used in the felony section based on the policies that we're going to go over from section 2B1. A gross misdemeanor, all of the rest of it is the same except the duration. For a gross misdemeanor, they're going to get a sentence of 91 to 365 days. But there still has to be a recording of guilt and then a sentence imposed within gross misdemeanor limits that they can either execute by sending them to jail or stay that. And then that offense will be used in the misdemeanor, gross misdemeanor section of criminal history. And then finally, misdemeanor priors. Those get sentenced to 90 days or less. So we normally think of 1 day to 90 days. That's a misdemeanor sentence. We still have to have that finding of guilt, and the sentence is also imposed but can be stayed or they can go to jail for that duration. And then we use that in the misdemeanor, gross misdemeanor section based on those policies we're going to go over from section 2B3. So when there is an imposed sentence, it is, I don't want to say it's super easy to determine what the level of sentence is. It's easier than the next type of sentence we're going to talk about. Because in Minnesota, we can do what's called a stay of imposition, where we don't impose any sentence duration that aligns with those statutes we just went over from 609.02, subdivision 2, 3, or 4. But we still have to have that finding of guilt. But what happens in these situations is the court will adjudicate guilt and then they will impose a specific period of probation. This can also include some jail time, but that jail time is considered conditional confinement as an element of probation. And when we try to determine how the level of sentence works in a stay of imposition, because we don't have any sentence duration imposed that aligns with these, like we do with an imposed sentence, then we have to go off the level of the conviction offense. So if you're convicted of a felony, it's a felony. Gross misdemeanor, there, misdemeanor, there. And it will remain that way until it is decayed. Now, there will come a time, hopefully, where they successfully complete their stay of imposition and they are through with it. And for non-criminal history purposes, that is reduced to a misdemeanor. But that remains at the offense level for use in criminal history until it decays. And unlike that statute that says this is the minimum sentence that can be imposed to have it fit within the felony, gross, or misdemeanor definition, there is no definition for probation. There is for probation. There is no statute that says, well, for a gross misdemeanor, you only impose 24 months. That might be the practice, but that's not the statutorily defined term of probation, which means we can never use probation or conditional jail time to determine what the level of sentence is. For a stay of imposition, we're always going to look at the offense that they pled guilty to and use that. And it stays that way until it's decayed, even if they successfully complete it. And we mentioned non-conviction disposition in the start of this conversation when we were speaking to that all-important judgment of guilt by the court, because that's how we know there's been a conviction. And a conviction is much more than a guilty plea or a finding of guilt by a jury. That conviction says, these folks said you did it or you've admitted doing it, but I, the court, am saying you did it. And now I'm going to impose sentence because you did that. But with a non-conviction disposition, and it's important right here to point out that this is a term that we use in training to differentiate between those offenses that require a disposition to be included in history and those that don't have a conviction. Because again, there might be a guilty plea. That might be part of the whole agreement that says you can get a stay of adjudication, but you have to enter a guilty plea. The court does not enter a final judgment of guilt. And without that, we have no conviction. And because we have no conviction, we can't have an imposed sentence or a stay of imposition. Now, we can certainly have a conviction with no sentence imposed, but we can't go the other way. We cannot impose a sentence without a conviction, which means unless that is revoked and a sentence is imposed or a stay of imposition, these types of dispositions are not going to be included in criminal history. So that would be something like a stay of adjudication. That would be a continuance for dismissal. I know they used to be called probation before conviction, which was very similar to both of those previously mentioned. But that's the important thing, is to think about, was there an adjudication of guilt by the court, that final judgment of guilt? And you need that before you can even move into thinking about criminal history consideration. Here we are at criminal history calculation. We're going to go over a couple of things before we get into each of the different components of criminal history. And the first thing that we want to talk about is a targeted misdemeanor, because we're going to use this term a lot. So rather than defining it every time, we're just going to define it once here. And then when we say targeted misdemeanor, we're going to know what this means. So only targeted misdemeanors are eligible for use in criminal history. And it is these 8 offenses that are eligible to be used in criminal history. And you can see that most of them are domestic offenses, but we also have indecent exposure and DWI on this list. And this list comes specifically from statute, where these offenses, upon conviction, require fingerprinting. And so that's what the legislature used to determine what a targeted misdemeanor is. And then the commission moved on to say, these are the only misdemeanors we will use in criminal history. And this list has been in effect since 2010. And so because I would have to say a large majority of the time we're using we're working on offenses that were committed within the last 5 years. I can comfortably say that because we're a little more than a decade past this rule going into effect, we can comfortably say these are the targeted misdemeanors that you use. But remember, if you have an offense that occurred before 2010, you're going to go back and use the guidelines in effect when that offense occurred to find those prior offenses. Another thing that we want to talk about before we get into criminal history calculation is talk about non-Minnesota or out-of-state priors. Because nobody that comes in here checks their offenses at the border. They bring that stuff with them, and we have to know how to use them. And one of the things that is both easy and confounding about non-Minnesota offenses is it doesn't matter what it was in that other state. It matters what it is here. And if we were in a training that I used to do, I would hold up my can of Diet Coke and I would say, when I moved here and I ordered a soda, I got a glass of soda water, because that's soda here in Minnesota, because you refer to it as pop. But regardless of whether it's a soda or a pop, it's a cola. In this case, a Diet Cola. And that Diet Cola is what we're focused on, not soda or pop. But that Diet Cola is what we're trying to equate. So that's what we want to think about when we're pulling a non-Minnesota offense into Minnesota. We're basically saying, do the same exact behavior here, and let's see what it would equate to. But for probation, who are oftentimes, this falls on your shoulders to make these decisions, you have the backing of the commission to say that the final decision is up to the court. So if you can't equate an offense, then don't try, because the court can look at not only the policies that are outlined in the guidelines about how things count, but they can also look at the nature of the crime. They can be a fact finder and dig in. And there's case law that tells them that they are eligible to do that, which is why the commission put this language in here. We want the court to be responsible for making that final decision that would then be argued by the prosecution and the defense. And it would be determined if and how something is used. And if something is not equitable to a Minnesota offense, the sentence doesn't matter. We often talk about burglary of a motor vehicle offenses that can carry up to 5 years prison. And this is out of Texas, and when you break it all down, the bottom line is the activity that they did in Texas often equates to tampering with a motor vehicle here, which is a misdemeanor and is a non-targeted misdemeanor. Therefore, it doesn't matter that they spent 5 years in prison on that offense. It doesn't count because it's ineligible. So we really want to remember that it's not, oh, they got a 5-year prison sentence, so it automatically counts. No, we really want to look at the nature of the crime and use that to decide whether or not it's eligible. And then we use the sentence to decide where it belongs in criminal history. But I think it's best if we always start with deciding if something counts, since that sentence is only going to determine where something will count. And there are some offenses that are clearly equitable, and those are the ones that we call threshold offenses, where the statute, which you can Google in the other state, what is a Class B theft offense in Wisconsin? You can Google that now and it will pop up. When I started, Google wasn't such a thing here, and now I Google stuff all the time and it tells me. And Google tells me that if somebody is convicted of a Class B theft offense in Wisconsin, they had to have more than $3,000. I'm probably just making this up, but you see where I'm going with this. More than $3,000. Okay. You have to have more than $1,000 or more than $5,000 to have a felony in Minnesota for a theft. So that fits comfortably in the middle. That's a theft between $1,000 and $5,000. We could easily consider that as a severity level 2 felony. And then we would look at the sentence imposed to determine, does it go in the felony section or does it go in the misdemeanor, gross misdemeanor section? And we're going to talk about this when we get into the different policies about how a sentence can actually dictate where something goes if it's sentenced below the offense level. Drug offenses, additionally, we want to look at how much and what type of drug the person had, and we really want to look at the conviction statute. We don't want to look at the complaint necessarily from the other state. We want to look at the statute they were convicted of, because that statute tells us what they had and what they did, and we want to use that. So as with everything in guidelines, we always say if there is confusion or concern, or you just want to talk something out, reach out to us. We're here to help. But the one thing that we're not going to do is do the heavy lifting for you. We're not going to be the ones that equate the offense. And I have to share this with you because it can be very frustrating for us at Guidelines. When we receive an email that says, this person committed a simple forgery in Tennessee, what would that be here? I don't know. I don't know. Not only is it a forgery, which means there are a plethora of things that they could have done, I don't know anything about forgery in Tennessee, nor do I need to know anything about forgery in Tennessee. I need to know about forgery in Minnesota. So those are the types of situations where it's best left to the judge. I can tell you, it is so difficult to equate criminal sexual conduct offenses from one state to another. There are 50 different definitions of rape in the United States. So we need to always be really careful with crim sex offenses. So again, I'm going to have to go back and say that if it's not a threshold offense or an offense where it's clear what makes it a felony in Minnesota, you might just want to pass those to the court and say, however you communicate with the court, say, Your Honor, these are ones that the court has to make the final decision on. The other thing that you might be able to do is if it's a federal offense and there is no Minnesota equivalent, that's going to be included in criminal history always at 1 point each. And if you're doing the electronic worksheet, there is a way to select federal as the jurisdiction where you can check a box that says no Minnesota equivalent, and it will assign the point but remove the severity level requirement. But I will tell you that there are drug offenses in federal court, so we always want to make certain that we're looking at how those equate before we just assign 1 point. When we're talking about a federal offense with no Minnesota equivalent, we're talking about something like transporting aliens across the border. That is not a Minnesota crime. That is a federal only offense, and that would get 1 point. So I think the thing that you can take away from here is you can only take that offense potentially so far before you have to turn it over to the court under the policy. And we have to remember that turning over to the court under the policy is doing your job as a probation agent, because your responsibility is to the guidelines, and this is what the guidelines say. So I always feel really bad when folks feel like they're not doing their job if they don't do it. That's not true. You're doing your job if you don't do it, because you shouldn't be doing it. So I don't want to belabor this point anymore, but this can sometimes be a hot button issue. So we always want to give it its full weight and discussion. So let's move on to enhanced offenses. Enhanced offenses really fit into 2 categories: DWIs and non-DWIs. And so that's really the easiest way to think about it. When we have an enhanced offense, the current offense is a enhanced offense. It's getting to that place because there are specific priors that allow the prosecutor to now charge that at a felony level. And so the commission has said, okay, because you committed a crime that would normally be a misdemeanor or a gross misdemeanor in other circumstances, but because you've done it enough, now it's a felony. Here's how we're going to treat those offenses that got you to that felony. So these are the ones that we call the offenses used to enhance. If a targeted misdemeanor, qualified gross misdemeanor, or felony is used to enhance, and the person is under eligible custody for that, that can be used to assign a custody point. However, those offenses used to enhance are not included in criminal history at the misdemeanor and gross misdemeanor level. Any felonies used to enhance, including juvenile adjudications for felonies when applicable, like in domestics, those can be included in criminal history. So, yes for custody, no for misdemeanor, gross misdemeanor units, yes for felony points or juvenile prior criminal history. One thing to keep in mind is when there are misdemeanors and gross misdemeanors being used to enhance, you only remove them from the offense they are enhancing, which means if they're being sentenced to another offense that is not being enhanced, those priors can be used in criminal history on that offense. So possibly you had a DWI and a flee peace officer. You'd remove the enhancers from the DWI, but put them back in criminal history on the fleeing a peace officer. But there is one time where we remove enhancers completely from criminal history consideration. and that is with felony DWIs. Felony DWIs, once you have a felony, you always have a felony. That's the way the statute was written. With respect to other non-DWI offenses, you have to enhance those every single time. There may come a time when all that is left are felony level offenses to be used to enhance, but that's different than not using the misdemeanors and gross misdemeanors to enhance. With DWI, once you have a felony, you always have a felony. And so the commission said, because you have a subsequent, we don't want to not only make all of the issues that go with having a subsequent felony DWI, we don't want to also increase your criminal history score from the 3 priors that were used to enhance the first felony DWI. So only for DWI are the 3 that are used to enhance the first DWI removed permanently from criminal history on future DWIs. But misdemeanors and gross misdemeanors used to enhance a non-felony DWI are eligible to come back on future non-felony DWI enhanced offenses if they're not used to enhance. So the thing that you want to remember is yes for custody, no for misdemeanor, gross misdemeanor, points, units, yes for felony. And never again DWI onto a subsequent DWI. The reason why we went over the non-Minnesota offenses and the enhanced offenses is because we want now moving forward to talk about eligible. So now we're moving into what is eligible to be considered for criminal history. When we talk a half a point for every adult level felony or EJJ, extended jurisdiction juvenile, EJJ, that is a lower level felony, a severity level 1 or 2, or a severity level D1 or D2, or a half a point for an eligible gross misdemeanor or targeted misdemeanor. All other felony level offenses or EJJ offenses that are found at the remaining severity levels, 3 through 12, D3 through D9, or anything off the sex offender grid, they're going to receive the full point. You'll notice that I have severity level 3 through 12. When we looked at the grid, it was only 3 through 11. That's because 12 is first degree murder, and that's not governed by the commission, but it's possible to be an offense that we have to deal with. So the commission assigned that severity level 12. So that's why we're saying 3 through 12 instead of just 3 through 11. These are the types of custody that somebody can be assigned for. Being assigned a confined status versus a probation status doesn't give you a higher point. Remember, what differentiates a half versus a full point is the level of the offense. Excuse me, the severity level, there we go, of the offense. But each of these is unique. And because we have ways to not assign custody, these are the ways that we do assign custody that we want to think about. So if they are on probation while serving that probation portion of the stay of execution or stay of imposition, which means they're in the community, we can give them probation as a custody status. If they are on parole, supervised release, or conditional release, they can receive the point. parole and supervised release, that's the post-incarceration portion of an executed sentence, versus conditional release, which is an extended period of supervised release for specific offenses like DWIs or criminal sexual conduct offenses. Conditional release is not conditions of release, which means they might be in pretrial status and they're they're not going back to jail. They're out in the community and the court gives them conditions of release and they commit a new offense. That's not when we would assign conditional release. If there is not a corresponding prior in criminal history of a criminal of a criminal sexual conduct or a felony DWI that you can correlate with that conditional release, then that's not the right offense. That's not the right status. Potentially what you might be wanting to assign is release pending sentencing. But you're not going to put in release pending sentencing if that term pretrial exists. Because to do release pending sentencing, this is when they've entered a guilty plea, there's been a guilty verdict, or there's been a conviction, and they're released to return later for sentencing, and during that interim period, they commit a new offense. That new offense would receive release pending sentencing. But pay attention because we need to have that guilty plea, guilty verdict, or conviction on that eligible offense that they were then released for to return later so that we can assign the custody to the offense they committed while they were awaiting sentencing. If they are confined, there are 3 ways that could be assigned as a custody status. So they commit the new offense while they're confined in jail pending sentencing. So that is the same as release pending sentencing without the release. They're pending sentencing following a guilty plea, guilty verdict, or conviction, and they go back to the jail and they commit a new offense. That new offense gets confined as the custody. They could be serving conditional jail time tied to a probation sentence. So if they're under that stay of adjudication or stay of imposition, but they're doing their 90 days in jail that the court imposed, well, they didn't impose it, that the court pronounced as an element of probation, there we go, then that would be confined as this custody status. Or the one that seems most obvious is following an executed sentence when they're either in jail or in prison and they commit the new offense. These are really going in order of most common to least common. I really could flip these last 2, but I think escape is important just to keep it tied to confined. This is when they escape and commit a new offense. You would give them escape as the custody status, but only if they escaped from prison. So they escape from prison, the term of imprisonment part of their sentence, and they commit a new offense. That's when you use escape. So it's probably more rare than EJJ, but I did want to keep confined and escape tied together. EJJ, that's when they commit their new felony offense before they turn 21. And they're under EJJ for under an EJJ conviction on a prior felony. The EJJ goes into it becomes the disposition when they are sentenced and remains in effect until they're 21. But if it gets revoked and the adult sentence gets imposed before they're 21, EJJ is not the custody status. possibly probation or confined. Something else would be the status. Additionally, if they complete EJJ and they commit their new offense, that is not a status. So you always have to verify that the prior offense that you're using, that they're not 21 yet when they commit the new offense, and that the prior offense that you're using is going in the felony section, because there is no custody assigned for juvenile offenses. These are all adult level offenses. And EJJ is on this list because the commission treats that as an adult offense because there is a conviction. If the defendant is placed on any of these types of custody and they abscond and commit a new felony, you can get the point for the applicable status even if it's since expired. So we see this a lot with supervised release, where they get on unsupervised release. They have to do 3 years of supervised release. They take off. That 3 years passes and they're not found until 6 years later. And they're found because they committed a new offense. They would actually get that supervised release custody status even though that 3-year term had passed, because when they abscond, the clock stops ticking. So they're still under that status even after it expires. If you work with sex offenders, this is something that you want to know with respect to assigning 2 custody points. And I think one of the easiest ways to think about this is, when do I not assign 2 points? And I'm not going to assign 2 points if my current offense is failure to register or the offense that they're on custody is failure to register. Because failure to register involves a lot more than just sex offenses. So the commission removed that as eligible, because the assigning of 2 custody points comes from the idea that you're being sentenced on a current offense that is ranked at severity level A through H, or A through G if it occurred before August 15th of 2021. And the offense that they're on custody for is on the sex offender grid, ranked at A through H or A through G if before September 15th, 2021. Which is why we can comfortably say, if the current offense or the prior offense is failure to register, you just give them the first point and move on. Because that's really something to think about regardless of what the prior offense is, because you can't give them the second point until you assign them the first point. So if someone is on failure to register custody status and they commit a child pornography offense, they're going to get the custody status for that failure to register. They're just not going to get the second point. No different than if they were on criminal sexual conduct. If their new offense was criminal sexual conduct first degree and they were in custody for a simple robbery, you would give them that custody point because they qualify for it. But you're not going to give them the second point because it doesn't qualify. So the bottom line is to always give them that first point. They are eligible for that. And then think about the second point, where that falls in the eligibility scale. It's just as important to know when you don't assign a custody as when you do assign a custody. So we're not going to assign a custody if they were under treatment or examination pursuant to a Rule 20. So this is when they're committed, so that they would potentially be confined, and this would not be how we would select confined. If they committed the current offense after August of 2010, when the targeted misdemeanors went into effect, and they're under custody for a non-targeted misdemeanor, you can't give it. Only those 8 prior offenses are eligible. Any custody related to juvenile, whether it's probation or confined, it doesn't matter. They're not eligible. Only EJJ offenses are eligible. So one really good cross-check is if the only place you're putting criminal history is in the juvenile section, your custody status will probably be blank. And I use probably because we always want to leave the door open for those anomalies, but it will probably be blank. If they're in custody for a misdemeanor, gross misdemeanor DWI that was committed by a 16 or 17-year-old, they're not eligible for custody. And in fact, you can take those prior misdemeanors and gross misdemeanors committed by 16 and 17-year-olds and just completely line them out. They're not going to be eligible for anything in criminal history. And then lastly, no longer eligible under Robinette is within original probation period, which we talked about, but also we never want to give out a custody status for a stay of adjudication. Under a 152.18, which is what it used to be eligible for, but now we just say no stay of adjudication period. And we oftentimes can get a little pushback because sometimes with a stay of adjudication, you enter a guilty plea. If they have entered a guilty plea, then release pending sentencing or confined is potentially their custody point when they commit the new offense. But if they have been placed on probation for a stay of adjudication, then despite the fact that they entered the guilty plea, they would not get any custody because the commission just does not allow for that. In 2019, the commission came up with a custody waiver, and after Robinette, this is eligible now for all offense states. And one of the things that the custody waiver is intended to do is be consistent with be consistent with public safety and promote sentencing purposes. The waiver remains discretionary with the judge. And I will tell you that as staff to the commission, I don't know whether or not an offender establishing that they will be consistent with public safety or that they are doing those things. I can't tell you whether or not someone should qualify for a waiver. So I think as staff, the best place that we land with the waiver is to tell you when it's not eligible. Because that's just as important, in my opinion, is knowing when it's not eligible as when it is eligible. Because when it is eligible, take it away. But let me help you determine when it's not eligible. So for the current offense or the prior offense that they're on custody for, the ineligible offenses are those higher ranked severity levels of 8 or above or D8 or above, or anything off of the sex offender grid at H and above, or at G and above if it's a pre-20, I keep wanting to say 2015, September 15th of 2021. Basically, failure to register is one of those bizarre things that sits out there. You know, you can't give it a half a point, even though it's a low level severity. You can't give it a second point, but you can waive the custody attached to it. So the sex offender grid, anything that is not failure to register on the sex offender grid is ineligible for waiver. We have offenses on the new severe violent offense list. I use the term new because it only came into effect in 2019, so it still remains, it's still got that new car smell to it. Fleeing a peace officer in a motor vehicle, great bodily harm. So only great bodily harm with respect to fleeing a peace officer. The other, great bodily harm resulting in death is at severity level 10, so that doesn't count. But there are two lower level, fleeing a peace officer, that do still make the person eligible. Or if they had an attempt or a conspiracy to commit any one of those offenses. So just to illustrate the point, here we have 3 defendants. The first guy is on probation for a crim sex and he commits a felony theft. The second defendant is on supervised release for a first-degree burglary with a weapon and they commit a criminal vehicular operation. It's actually a criminal vehicular homicide that they've committed. And the third defendant is confined for a gross misdemeanor theft, and they commit a felony violate no contact order. So who's eligible for the custody waiver? One of the most important things that we want to remember is it's not the type of custody that they're under. So it doesn't matter if it's confined versus probation. What matters is the severity level of the prior offense, which means that defendants and the current offense, which means that defendants 1 and 2 are going to get a custody point. Defendant 1 is on probation for a crim sex offense, and defendant 2 is not only on supervised release for a higher level offense, they committed a higher level offense, a criminal vehicular homicide. Both of those are actually ranked at severity level 8. So only defendant 3 is eligible for the court to consider waiving the custody status point. So again, it's not the type of custody, it's what that custody is for that dictates whether it can be waived. Okay, moving on. Juvenile priors. This falls under section 2B4 of the guidelines. And we can only use juvenile priors under extremely specific situations. The first one being that they're under 25 when they commit the current felony. And the second one is that they're over 14 when that prior juvenile offense was committed. That prior offense must be a felony that was adjudicated delinquent in juvenile court. That is very important. Adjudicated delinquent in juvenile court. That can knock some non-Minnesota offenses out of eligibility to be used because some states will take 16 and 17-year-olds to adult court regardless of what the offense is. So we have to be really careful when we're looking at criminal history, that we look at the age of the defendant and then we see where they went. In order to make a point, you need 2 priors. There are no half points or quarter points or anything like that. There's just 2 priors, make 1 point. And you want to list all eligible priors on the worksheet. There is a provision in 2B4 that allows for the assigning of more than 1 juvenile point for a defendant. But that can be under very particular situations, specifically offenses that are presumptive commits. So what we want to do in this situation is say, if you've got a client with a lot of juvenile criminal history, let's talk that over. because what we don't want to lose sight of is how we make 1 point. We want to hang on to that policy, and then we want to talk on an individual basis about whether or not there may be qualifying second or subsequent points. For misdemeanor and gross misdemeanor offenses, Section 2B3 of the guidelines, we want to include all targeted misdemeanors, all non-traffic gross misdemeanor or reckless driving offenses that are sentenced as gross misdemeanors or gross misdemeanor DWI and refusal to test. Why do we call out those non-traffic gross misdemeanors and reckless driving as sentenced as gross misdemeanors? Because a gross misdemeanor offense, in order to be included, must be sentenced as a gross misdemeanor, so 91 to 365 days imposed, or a stay of imposition for a gross misdemeanor offense. If it's not, if it's sentenced below the offense level, so it's given 90 days or less as a misdemeanor, it has to be on the targeted misdemeanor list, which is why we move DWI and refusal to test away from that, is because those are on the targeted misdemeanor list. So again, your gross misdemeanor offenses, in order to count, not traffic offenses, and must have received a gross misdemeanor level sentence or a stay of imposition for a gross misdemeanor. Additionally, this is where we can include any felonies that were sentenced to less than a year and a day. So this would include felonies sentenced anywhere between 1 day and 365 days as the imposed sentence. Remember, a stay of imposition for a felony is going to stay in the felony section. But if they get an imposed sentence of less than a year and a day, then you can use it here. They have to have received this imposed sentence or stay of imposition prior to sentencing on the current offense. As we moved through the custody status point, we kept emphasizing the idea that they commit the offense, are placed on custody, and then commit the new offense. So it's the offense that they're on custody for when they commit the new offense that dictates the custody point. Whereas with all of these types of criminal history components, felony, misdemeanor, gross misdemeanor, and juvenile, we just want those to have been sentenced prior to sentencing on the current offense in order to include them in criminal history. So even if the prior that you're using was committed after the current offense was committed, it's still eligible if it was sentenced before the current offense. So that's kind of an important thing to keep in mind, that we're just looking at whether or not it received an imposed sentence or stay of imposition prior to sentencing on the current offense. And then as a reminder that it was not used to enhance the current felony if that's the case. The decay factor is 10 years from the date of the initial sentence on the prior to the date the current offense occurred. And what we mean by initial sentence is the day that they received their stay of imposition, stay of execution, or confinement. That's the original sentence. Any revocation that occurs later on is past guidelines jurisdiction. The original imposed sentence is the date that you're going to use for the disposition date, and then add 10 years to that to see if it's decayed based on the date of the current offense. In order to assign the points, we want to give each prior 1 unit. And then we want to have 4 units to make 1 point. And that is the maximum number of points that people can get, regardless of how many priors that they have listed on the worksheet. That is the maximum number of points that they can receive, except if the current offense is a DWI or criminal vehicular operation. And in that case, we assign eligible prior DWIs and CVOs 2 units each. And there's no limit to the number of points that you can get assigned for these types of priors in this felony situation. I want to treat that bullet point exactly the same way that we treated the additional points for juvenile. I want to say, if your current offense is a DWI or a CVO and you have a lot of misdemeanor, gross misdemeanor priors, some of which are eligible DWIs and CVOs, give us a call. Let's talk through it on an individual basis, because there are ways to configure the criminal history that can result in multiple points. And when I say there are ways to configure the criminal history, these are all ways that are eligible under the guidelines to make more than 1 point. But I would rather do it on a one-on-one basis, again, because we don't want to lose the idea of the first point. Someone might have 25 prior eligible gross misdemeanor theft offenses listed on the worksheet. They're only going to get 1 point. We never want to think of that person as eligible for more than 1. So that's why I would say give our office a call, and we're going to go through how that potential second or subsequent point might be added. Before we do felonies, I want to talk about 5th-degree drug offenses. In 2017, we had a case, State v. Strobel, that got decided that talked about 5th-degree offenses that could. So basically what happened is Mr. Strobel had a trace case, what we used to call trace cases, that was committed before August 1st of 2016 when the drug laws changed. And he argued that had he committed his offense after August 1st of 2016, he would have been charged with a gross misdemeanor. And he was absolutely correct in that he had the required amount of cocaine to be a gross misdemeanor, and there were certain other elements of it that would have left it as a gross misdemeanor. And so again, this was affirmed by the Supreme Court. So we have State v. Strobel. And State v. Strobel requires that we ask 3 questions of the very first 5th-degree drug we are putting in criminal history. And I want to emphasize that this is the first 5th-degree drug of prior criminal history. This is not if the current offense is a 5th-degree drug and the offense date is after August 1st of 2016. That's taken care of. That's off the table. These are the prior offenses in criminal history. So, 2 dates to think about. The current offense occurs after August 1st of 2016, and the prior offense that we're talking about occurred before August 1st of 2016. The first question that we ask may seem ridiculous given we just went through all those dates, but did that 5th-degree prior in criminal history occur after August 1st of 2016? Because if it occurred after August 1st of 2016, we have to assume it was charged at that time the way that it was intended to be charged. So again, did this prior offense occur before August 1st of 2016? Yeah, that's the Strobel question. Was the current drug marijuana or was it sale? And the reason why we asked that one question with those 2 different components is because the 2016 drug laws only affected possession of non-marijuana drugs. The third question we want to ask is, Does the offender have a prior drug conviction, including for petty offenses or decade offenses? And again, they have to be convictions, no non-conviction dispositions. So no stay of adjudication, continuance for dismissal. Must be convictions. So this is pretty straightforward. If the answer to all of those questions is no, the offense did not occur after August 1st of 2016, it was not marijuana and it was not sale, and the person has no prior offenses, then that has to go in the gross misdemeanor section unless the prosecutor in the current case has established that that drug is more than a trace amount. So my suggestion is you move it to the gross misdemeanor section if that's where it belongs. And if the prosecution says, wait a minute, that should be in the felony section, then they need to attest to that fact. But let's just pretend, for the sake of argument while we're on this slide, that you answer yes to any of these questions. The prior offense occurred on or after August 1st of 2016. No, it's still a pre-2016 case, okay? The drug was marijuana or it was sale. No, it was possession of cocaine. The offender has a prior drug conviction. Oh yeah, they have a 1998 motor vehicle marijuana in a motor vehicle conviction. Okay, I've answered yes to number 3, which means Strobel no longer applies because according to statute, it's only their first drug offense under the required weights that is eligible to be charged as a gross misdemeanor. Certainly we know that's always up for discussion, but for the sake of Strobel, we know that that's the case. So let's say as probation, you're like, no, he's got that prior drug offense, so I'm going to leave that there, and I'm not going to put any notes, and I'm going to leave that as a severity level 2 offense, and I'm going to submit this worksheet for review. I can guarantee you that's going to come back to you with these questions. Did you deal with Strobel? And the reason why is there's no notation that it was a subsequent, and the severity level is still a 2. If that meets Strobel, I have to hope that after going to all of the effort to determine if Strobel is eligible, or if it's eligible under Strobel, excuse me, to be used as a felony, that you would move that to a severity level D2. And I have to, and when I say I really do mean we have to send back worksheets that show up as 2s. But if it shows up as a D2, then we have to move on because we're looking at so many worksheets. We can't ask questions of every single prior on every single worksheet. So we have to assume things have been updated accordingly. And if you update that to severity level D2, we assume you've applied Strobel. But if you leave it as a 2, we can't assume that. So we have to ask the question. So save yourself some time, ask the Strobel questions, and make sure the severity levels are updated. When we have felony priors found in section 2B1, to include a felony, it has to be, of course, a Minnesota felony, a non-eligible, an eligible non-Minnesota. That's the right order, an eligible out-of-state felony, an EJJ conviction. Those are the eligible felonies, and as long as they've received a sentence of at least a year and a day before sentencing on the current offense, they're eligible to be used as criminal history. Excuse me, a year and a day or a stay of imposition. Before sentencing on the current offense, they're eligible to be used in criminal history. We want them to not be decayed. There you go. If it's a prison sentence, we want that decay factor as 15 years from the date of expiration of the sentence, which means the full term of imprisonment, the full supervised release, and if applicable, any conditional release, to the date the current offense occurred. Now that's if they went to prison initially or were later revoked and went to prison. That's how it decays. But if it was a non-revoked probation sentence, which means they stayed on probation the entire time, then it's 15 years from the date of the initial sentence of the prior to the date the current offense occurred. Felonies, however, will not decay while they're still under custody. And again, initial sentence means the initial commit, the initial stay of imposition, or the initial stay of execution. If you have a stay of adjudication that gets revoked and a stay of imposition, for example, is imposed, that stay of imposition date, that's the date of the offense. Excuse me, of the disposition. If you have a stay of execution that gets revoked and sent to prison, that's where we move up and go to the prison sentence for decay. But if you have a stay of imposition that gets revoked and gets a stay of execution, that stay of imposition is still the original date of sentence. So those are what MSGC catalogs as the initial sentence, when it's a stay of imposition, a stay of execution, or prison for felony, jail for a misdemeanor, gross misdemeanor. We're going to assign points that are based on the severity level of the prior offense using the guidelines in effect when the current offense occurs. And we're going to equate that severity level to a point value based on the grid that the current offense is being sentenced from. So, pretty easy way to figure that part out. If the current offense is being sentenced off the standard grid or the drug grid, it means it's being ranked at a severity level 1 through 12 or D1 through D12. Please remember that murder in the first degree is a 12. So even though it's technically not sentenced off the grid, it does follow the standard or drug grid with respect to weighting priors. So you can see we have the severity levels and how they equal points. And then we have the standard and drug grid severity levels, and then we have the sex offender grid levels and how they equate to points. If the current offense is sentenced off the sex offender grid, then you're assigning an alpha severity level to that. The severity levels for those priors off the drug or standard grid are the same. Additionally, murder is the same, 2 points, but the severity levels and the points for the severity levels off of the sex offender grid will increase. So when it's a sex offender offense off the sex offender grid and there are prior offenses that equate to the sex offender severity levels, then we increase the point value. And just for example, we go back here, we can see that a severity level A is 2 points. If we come here, we see that it's 3 points, and that's because the current offense is off the sex offender grid and the prior is found on the sex offender grid. Oops. Wow, I did not mean to push end. I meant to push page down. Yes. Here we go. Paging down, we're going to find the presumptive guideline sentence now. So we're going to take all of that work that we did finding the severity level, all of the work that we did calculating the criminal history score, and now we're going to apply it to the grid. The grids all work the same, remember? So you just have to find the severity level down the side and the criminal history score across the top. And where those meet is going to be your presumptive sentence. But each of the grids has that column 6 or more. And you see that this grid up there at severity level 11, 6 or more has 480 with a 2. Felony DWI at severity level 7, you go across, you see 84 with a 2. Sometimes, if the commission's calculation of the upper range of 20% exceeds the stat max, we have to pull it back and put the statutory maximum on the grid. So on all of the grids, you might see something that looks like it's wrong. And it's actually not, because of that statutory maximum issue. That's going to become something to think about when we explore the or more part of the grid. This is the or more part of the grid, and this is called the custody status enhancement. And this is if the total criminal history score is off the grid, quote unquote, which means it's 7 or greater. And one of those components of those total 7 points comes from custody. We're going to add 3 months to the presumptive sentence. We're only going to add that on one time, regardless of how high their criminal history score goes. But we are going to add on 3 months to the presumptive sentence. But we have to be certain that we don't exceed the statutory maximum if that's reflected on the grid. So that's what I was talking about when I said, I think murder in the second degree at the top, severity level 11 is a good one. If they have a criminal history score, let's say their criminal history score is 9, and they have a custody status point as part of those 9 points, you would add 3 months to the grid. You would take that 426 and make it 429. The lower duration, 363, would become 366 by adding the 3 months on. But you would be unable to add that 3 months on to the upper range of 480 because that's the statutory maximum, and the sentence cannot exceed that. If we drop below to a severity level 10 or a 9 or an 8, in all of those, you could add the 3 months on to the upper range because the statutory maximum is not reflected. So that's just something to keep in mind if you're wondering why you're looking at the worksheet and you're seeing that they have this 3-month enhancement, but it's not showing up. It's possibly because there's a stat max. But one of the reasons why it won't show up when you're looking at the sentencing worksheet is if they do not have a criminal history point. In that situation, regardless of how high the total criminal history score goes, they don't have a custody point. They don't get the 3 months. So if you're thinking to yourself, their criminal history score is 20, why don't they have the 3 months? Remind yourself what the name of the modifier is. Custody status enhancement. No custody, no enhancement. And one of the last parts of the presumptive sentence is a maximum term of probation for most felonies. This policy went into effect August 1st of 2020, and currently, as it stands, it is only in effect for offenses committed on or after August 1st of 2020. This was not in effect when Mr. Robinette appealed his case, which lowered his criminal history score in his sentence. Sorry about that. And so we're looking at offenses committed on or after August 1st of 2020. We'll have a stat max for probation of up to 5 years. These are the offenses that are excluded from the length of stay policy. And I have 2 different charts here, depending on how you prefer things. If you prefer them by statute, or if you prefer them alphabetically. But these are the offenses that are not going to have this cap on probation. Just a reminder we talked about the level of sentence. We have a stay of execution or a stay of imposition. We have a finding of guilt, and then we either have a term that is imposed and then stayed, or we have the conviction but no sentence duration imposed and a disposition of a stay. So when the court is trying to determine what the maximum length of probation will be, the way we look at it is we say the probation term will either be 5 years or the statutory maximum, whichever is less. Or it will be 4 years if the statutory maximum is under 5 years. If the stat max is under 5 years, then the term of probation is 4 years or the stat max, whichever is longer. So that means the stat max for offenses is going to be 5 years or 4 years. Most offenses are 5 years. Offenses that run in that 4-year range that have a stat max below 5 years are going to be offenses like fleeing a peace officer in a motor vehicle, are going to be domestic assault by strangulation. Those have a stat max under 5 years, so those are going to reflect that 4-year that 4-year probation max. And if the court exceeds that term, then it is considered a departure, and the court will have to articulate substantial and compelling reasons to support the departure from this policy. But the departure cannot exceed the stat max of the offense. And one of the things that the guidelines took a look at when they were determining how these departures could be established is that they said that they could be established based on the individual characteristics of the offender, as opposed to what is normally required is departures based on the nature of the offense. So the commission recognizes that it's absolutely crucial that the court retain its departure ability in all situations, but they still do have to report it to the commission. And this is something that is printed on the worksheet because it is part of the presumptive sentence. So any worksheet is going to have the box where the sentence is with the disposition, the duration, and then the maximum length of stay. In the first box, we can see an offense that has a 5-year stay. In the second box, we can see that the disposition is a commit to the commissioner. So the court is being informed that if they choose to depart and stay the sentence, they are limited to a 5-year stay. And on the last box, we can see that this is one that does not qualify. I'm going to guess that this is a sex offense because we have a conditional release term here. This one does not qualify for that probation max. So in that case, we input the stat max of the offense. That started appearing, and that does appear regardless of whether it's a pre-plea or a completed and reviewed worksheet. So if you have to highlight it, perhaps on the printed worksheet, that might be a good idea because we did have quite a few departures in this last round of requests that we sent where the court didn't realize that they had that, that they were prohibited in imposing longer than eligible probation terms. So that brings us to the end of this training. Again, this was a fundamentals training. If you find yourself in a situation with those more intense offenses, perhaps they have a weapon, perhaps there are multiple offenses, those are really good individual one-on-one situations where we can talk through them. But these are going to be the policies that you apply more often than not. But nevertheless, no matter how simple or complicated something is, we are always here to assist you. We've got our website where you can find additional information regarding offenses, including all of the sentencing guidelines books back to 1980. Or you can send us an email and we can help you out that way. And right now, because we're teleworking, email is actually the best way to reach out to us. So I thank you for your time today. I hope you found this valuable and take care. Have a wonderful day.